Welcome back. In this video, we are going to talk about legal defenses to anti-competitive legislation. So this is our second video in the 5-part series for Chapter 10. Okay, so a few notes before we start. First of all, this idea of when can Congress overturn a court ruling. So sometimes they can and sometimes they cannot do this. And so you might be wondering, well, when is that possible? When can you go to Congress and ask them to overturn some ruling that the court made? You know, haven't we been talking about how the court has the final say? Well, the court has the final say in constitutional issues. So if the court says that a given statute violates, for example, the free speech rights, okay, then and that is, it's unconstitutional to have this given kind of restriction on speech. Congress, there's nothing Congress can do. Congress can't pass any law that can make that kind of activity constitutional if the court has ruled it unconstitutional. Now, what the legislature can do is amend the law to deal with whatever problem the court has identified and hopefully make their law constitutional. So they can change the law, but ultimately, on the question of whether a law is constitutional or not, only the court can make that decision. But in cases of legislative interpretation, so this is when the court is saying, you know, there's a dispute over what the legislation means. So there's a law that provides for some rule, and the two parties are interpreting that rule differently. And the court will step in and say, okay, well, we think the legislature meant it this way. Well, in that example, the legislature can then, if they don't like that ruling, can pass another law or amend the law to say, no, we really meant it this other way. We're going to fix that. We meant it in a way other than the way that the court interpreted it. So in constitutional challenges, the court has the final say. In legislative interpretation, Congress can overrule a court ruling on that issue, on interpretation. So there are a number of examples of this in Chapter 2. I won't go back through them, but if you're interested, you can go back now in retrospect and kind of read through Chapter 2 and rethink through some of those examples. So how do you defend then when a competitor is using is obtaining legislation that is anti-competitive, right? Is lobbying for and successful in getting Congress to pass a law that is anti-competitive. So there's 3 ways that you can challenge this. One is through this constitutional challenge provision. So you can go to the court and say, hey, this law is unconstitutional. And if you're successful, then, and the court rules that way, there's nothing Congress can do except change the law to something that meets whatever constitutional standard the court sets. The other option is, once the law is in place, you can go and lobby for the regulatory rulemaking. Most statutes, as we have learned, delegate most of the details to a regulatory agency to implement. And so the battle can sometimes take place at the regulatory agency stage as opposed to the creation of the legislation. And then lastly, there are some limited ways that you can sue under antitrust law. However, as we'll see, for the most part, there is pretty much blanket immunity for that, which means that it's very, very difficult, if not impossible, to sue for anti-competitive behavior in the legislative process. Okay, so let's look at how you might challenge a statute under some constitutional provision. So again, the Supreme Court of the United States is the sole and final arbiter of what is constitutional and what is not. There are also, though, don't forget, there are constitutions in every state. So it's not just the Supreme Court of the United States that's involved in this game. It is the state Supreme Courts as well. So if you have a statute that the state Supreme Court rules is in violation of the state constitution, then it's very similar as is the case with the Supreme Court. And that cannot be appealed into the federal system unless it involves an issue of federal constitutional law. So let's say it's a question of First Amendment free speech rights or whatever. Okay, that's a federal issue. Many state constitutions also have protections, free speech protections. So if a case is brought in the state system under the state constitutional provisions, protection of rights, and the losing litigant in that case is unhappy, and they can make an argument under the federal constitution, then that can be appealed out of the state system. But for the most part, unless it violates the federal constitution in some way, the state Supreme Courts have final say on the constitutionality of laws under the state constitution. So it's not just a battle that's fought at the Supreme Court of the United States, it's also in the state Supreme Courts. Most of the time, the court will apply some form of what we call a balancing test. And I won't go into all of these, but there are a variety of balancing tests that the court uses to decide whether a government restriction is a violation of the Constitution. And remember, and I'll get to this actually in the next slide, but when we're talking constitutionality, we are only talking about government action. So the Bill of Rights only protects you from government action. So it doesn't protect in private situations. So we'll get to that in a moment. So we're only talking about the government taking some kind of action that is alleged to violate some provision of the Constitution. And when that happens, the court looks at two things. They look first at what right is involved, and not all rights are the same. Some are what we call fundamental rights. So the right to free speech, the right to free exercise of religion, those are considered fundamental rights. So the court applies a much stricter standard to any restrictions on those kinds of rights than it does, for example, to things like commercial speech. So a company's right to talk about its products, that there is a right to do that, but the government has much more leeway to regulate that kind of speech than it does to private political speech, for example. Okay, so they balance, what kind of right is it? What level of right is it? And what is the purpose of the law? So one of the things, and it's funny how things work, but I was just emailing with a former student this morning who was asking about some of these local jurisdictions that are defying gubernatorial orders having to do with the shutdown involving the pandemic. And what's interesting is that there are some people who are saying, look, I belong to a church, I have a right to free exercise of my religion, so the government can't put any restrictions on my free exercise of my religion. And that's just simply not true. Even fundamental rights are not absolute. They could still be limited, but they have to be limited by very narrowly tailored restrictions that are designed for a very important governmental purpose. That is the highest level of scrutiny that a rule like that would get. So, for example, if you had a religion that believed in human sacrifice, the courts would support a government restriction on the exercise of human sacrifice. Okay, you can't do that, even if it is your religion. Similarly, if you belonged to a religion that believed in the overthrow of the government, well, the government could restrict activities that would result in the overthrow or the armed overthrow of the government, for that sort of thing. So you don't have an absolute right to practice whatever religious practice you want whenever you want, but the government, if they are going to restrict exercise of religion, have to do so under very, very limited circumstances. And in the case of the pandemic, where the government is attempting to protect people and closes all gatherings, restricts all gatherings of more than 10 people, then it's permitted to do that for churches as well. What it couldn't do is say, we're just going to restrict church gatherings and let other gatherings of similar or larger sizes happen. That would not survive the scrutiny of the courts. Okay, so it's important to understand that there is this balancing test, and that the balancing test does vary by the type of right that's involved. Now, before we move on, there's one update to the book. So the book was written in 2004, and subsequent to that, there was a major case that came out of the Supreme Court called the Citizens United case. This happened during the Obama administration. And what the court said was that corporate contributions are protected under the First Amendment and effectively allowed unlimited corporate contributions to political campaigns. And that has affected the elections since then. And there are many out there who hate this decision and would like to overturn it, but there's simply, because it's a constitutional question, like I mentioned earlier, there's nothing Congress can do about it. The only solution would be either to hope that there's a change in personnel on the court and get a new case and have a new court with different justices on it rule in a different direction, overturn the Citizens United case, or amend the Constitution. That's the only other way that you could do that. Because ultimately, remember, the court has the right to determine what the Constitution means, but ultimately there's this process for amending the Constitution so we could change it to say corporations can't contribute to political campaigns, and then the court would be bound by that if that's what the Constitution said. But it's very, 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 very difficult to change the Constitution, or to amend it. So that's something that this book, because it was written before that, he makes reference to the fact that the government can restrict corporate political campaign donations, but the court has since changed the rule on that. Okay, so some of what I was on this slide I've kind of already talked about in the case of free speech. So free speech is only protected against, let's put it this way. Your right to free speech only applies vis-a-vis government action. Okay, so if the government says you can't say this or you can't say that, there's restriction on your speech, and this is a very broad and very fundamental right, then the court will often find that to be unconstitutional unless it passes this very strict balancing test. However, commercial speech, which I've already mentioned, is not considered the same fundamental right. So for this reason, the government can restrict advertising messages, they can regulate advertising messages, and they can restrict the kinds of speech that a business can be involved in ways that they could not restrict an individual from speaking. So free speech, constitutional free speech prohibitions are easier to survive constitutional scrutiny if they involve commercial speech. Now, under the Commerce Clause, which we've kind of already talked about before, this deals mostly with who can regulate what. And as we've learned, I think we talked about this early in the class before even we went to distance learning, Congress can pretty much regulate whatever it wants. The Commerce Clause has been interpreted very broadly to give Congress the power to regulate pretty much anything having to do or that even touches interstate commerce. So it gives this Congress power to regulate, but Congress doesn't regulate everything. And it chooses sometimes not to regulate in some areas, in which case the states can often regulate those areas of activity that Congress has not. But the states are not free to do whatever they want. They can't discriminate against interstate commerce. So this is and we've talked about this this was a key legal concept in a previous video. This is the dormant Commerce Clause area. So what the Dormant Commerce Clause means is that the court has interpreted the Commerce Clause to mean that if Congress doesn't regulate, that the states can regulate so long as they don't interfere with or discriminate against interstate commerce. So we had this New York winery example where New York said that only in-state wineries could ship directly to consumers, and the court said that no, that was an improper restriction on interstate commerce. So some regulations, like that New York winery regulation, can be attacked under Dormant Commerce Clause theory. So that would be using a constitutional challenge to fight a regulation. And in fact, that's exactly what happened in the New York winery case. Is there was a lawsuit, and the Supreme Court ultimately sided with the out-of-state wineries, arguing that New York's regulation was a violation of the Dormant Commerce Clause. If the states are going to regulate in this way, the balancing test is they have to prove that they have that the benefits of this regulation outweigh the discrimination against the out-of-state vendor, out-of-state companies. And in the New York winery case, the argument, the government purpose that New York cited was safety, that they didn't want wine being shipped to minors. And the court, of course, saw right through this and said, well, you can get drunk on in-state and out-of-state wine the same way. So that was just a false reason, and it wasn't sufficient to overcome the discrimination against interstate commerce. So that's how you would attack a law or some sort of rule based on the Commerce Clause. Okay, so then there's two other constitutional challenges that the book discusses. One is a challenge based on a due process or equal protection. And so as we've talked about in this class already, we all have a right to due process, to a fair procedural process, as well as a fair treatment by the government and equal protection by the government. That's part of the Bill of Rights. And so as long as if the government is doing this, is preventing due process or equal protection, if there's a law that does that, it can be attacked on that constitutional basis. But what's interesting is that what's happening as the economy changes is a lot of this due process is being moved into private institutions. And so one example is if you're a seller on Amazon and they shut down your store for some violation of the contract, that is not subject to constitutional due process protection because it's not government action. So as long as it doesn't violate some other rule, you can't attack a private due process procedure under the Constitution, only government action. This is also true in Facebook, where they take down posts that they think violates their contract. Twitter does the same thing, and you are stuck with whatever procedure those companies offer, and they don't really even have to offer a procedure. They owe you no obligation of due process. All they owe you is the obligation to comply with whatever contract you signed, which of course is very favorable to them. This is where, for this area, for due process and equal protection, there's a much lower bar. It's what we call a rational basis. And so as long as the government has a rational basis for the regulation, it will often survive due process and equal protection. So it's a lower bar than is the case for things like First Amendment free speech rights. And the last is the power of the states to tax, or Congress to tax. In this case, what's interesting is that the states and Congress can tax in unfair ways if they want to. There's there's nothing that says that the government can't tax one industry more than another, and it often does this, or one kind of product more than another. There's very little protection against that kind of activity. So if it turns out that your competitor lobbies for and wins a tax that makes your product more expensive, your really only option is to lobby Congress to change the rule, even if that's anti-competitive. So that's why Shell points out that you really need to be good at lobbying if it's a taxing case. So this is why it's important to understand what kind of problem you're dealing with. If it's a constitutional problem, if it's a free speech question versus a Commerce Clause or due process or taxing question, you're going to use a different defensive strategy to attack it based on the constitutional rights and the way that. Okay, so regulatory maneuvering and antitrust. So if again, remember we're talking here in this video about anti-competitive legislation. So how do you deal with that? Well, you deal with it by potentially sometimes by attacking the regulation, the regulatory implementation of the statute. And so this, of course, we've seen many examples of this throughout the book. This requires lobbying expertise, and there's really not, we'll talk more about that actually in the next video. Now, what about suing the legislature or the parties who are petitioning the legislature to create anti-competitive legislation? Well, effectively, you can't do that. Effectively, legislators are exempt, and for the most part, pretty much everybody who lobbies a legislator to pass an anti-competitive piece of legislation is also exempt. And the only exception to this is what we call sham exception. But the way that the court has applied the sham exception, there's never been a case where it's been enough of a sham that the legislator or the litigant is subject to anti-competitive litigation. So it's almost, basically what this is saying is, it's almost impossible to sue if the legislature creates a law that is an anti-competitive disadvantage for you. There's really no antitrust lawsuit avenue for that, unless it's a complete and total sham, and that's never been proven before. So the standard is pretty rough, and that's not probably going to be a winning strategy. Okay, what questions do you have? Lots of law, lots of constitutional law in this video. Is there anything that was maybe not so clear that I can clear up for you? Any questions, comments, or thoughts, examples? I hope to see those in the forum. Thank you for watching, and I'll see you in the next video.